The decision comes as former President Donald Trump tries to prevent his federal election interference case from moving forward. Trump's lawyers appealed, saying that the charges that he tried to steal the 2020 election could not stand because of presidential immunity. The country's highest court said that presidents do have immunity, but only for a narrow set of actions related to their duty as president. Personal actions can still be prosecuted. Now, a lower court will determine which charges against Trump still qualify.
Let's start with the Supreme Court ruling that changed the future of presidential power. The Supreme Court has issued a ruling that changes the way presidential power and criminal accountability will be understood for years to come. The court recognized that presidents can have immunity for certain official acts, especially when they are using the core constitutional powers of the office. But the ruling did not give Donald Trump the unlimited protection he wanted. It did not say a president can commit any act, call it official, and escape consequences forever. Instead, the court created a framework. Some actions are absolutely protected, some may be protected depending on the circumstances, and private conduct receives no immunity at all. That final category is where Trump's biggest legal danger remains. Now let's see why Trump's total immunity argument did not.
Well, Amaka, a very big decision. The U.S. Supreme Court deciding for the first time in American history that American presidents do have some immunity for official acts, and President Trump included among them, some immunity for official acts while they are in office. Chief Justice John Roberts wrote that presidents have immunity for official acts in office and absolute immunity for core constitutional powers. Justice Roberts said former President Trump's conversations with his attorney general are protected.
Succeed. This ruling came out of the criminal case involving Trump's alleged effort to overturn the 2020 election. Trump's legal position was broad and aggressive. He argued that because he was president, he should be protected from prosecution for actions taken while in office. He wanted the Supreme Court to wipe out the case entirely. But the court did not go that far. Instead, the justices separated presidential conduct into three groups. First are core constitutional functions, where the president receives absolute immunity. Second are other official acts, where immunity may be presumed but can still be challenged. Third are private acts, where there is no immunity. This next part explains the three categories that now define presidential immunity.
They ruled that presidents have, quote, absolute immunity from criminal prosecution over what the justices said were, quote, official acts, in a critical case over whether Donald Trump can be charged for allegedly plotting to overturn the results of the 2020 election. The landmark ruling recognizes, for the first time ever, any form of presidential immunity from prosecution. The 6-3 decision, written by Chief Justice John Roberts, split down partisan lines and threw out a lower court's decision rejecting Trump's claims of immunity from criminal charges.
Immunity. That distinction is now extremely important. A president may be absolutely protected when using core powers like commanding the military, issuing pardons, appointing officials, or directing certain executive functions. The court also gave presidents strong protection for some other official conduct, but personal conduct remains personal conduct. A president does not get to turn private schemes, campaign activity, hush money payments, business fraud, or post-presidential behavior into official acts simply by holding office. That is the line Trump wanted blurred, and the court refused to erase it. Now watch why Trump's legal force field argument collapsed.
Well, good morning. I mean, it means that Trump is all but certain to go to the Supreme Court and ask them to intervene. He's got till Monday to do that. And whether or not the justices take up this case, that could determine when Trump goes to trial.
From the courthouse to the campaign trail, former President Donald Trump has insisted he should be immune from criminal prosecution.
Trump's entire legal defense had depended on the idea that the presidency created a shield around him. He wanted a kind of super immunity, a legal force field strong enough to stop prosecutions before they could reach him. His lawyers argued that the president's responsibilities are so demanding that he must be protected from criminal accountability for a wide range of conduct. But the Supreme Court did not give him that total protection. The court made clear that the presidency is powerful, but it is not a monarchy, and private wrongdoing can still be prosecuted. Here is why the New York hush money case remains.
The U.S. Supreme Court's conservative justices on Thursday signaled sympathy to the argument that presidents have some immunity against criminal charges, as Donald Trump seeks to be shielded from special counsel Jack Smith's federal election subversion case. During oral arguments, conservative Justice Samuel Alito expressed concern about presidents having to worry about being indicted after leaving office.
Will that not lead us into a cycle that destabilizes the functioning of our country as a democracy?
So dangerous for Trump. That matters because some of Trump's most serious cases involve conduct that does not look like official presidential duty. The New York hush money case is one of the clearest examples. That case involved payments connected to a presidential campaign, an alleged effort to silence an adult film actress, and falsified business records used to disguise the true purpose of the payments. None of that is a military decision. None of it is a pardon. None of it is an appointment or diplomatic act. It was conduct tied to personal reputation, campaign image, and private benefit. Under the Supreme Court's framework, that kind of conduct does not fall inside the protected core of presidential power. Now let's look at the 34 felony convictions that still hang over Trump.
Maurice, people in the courtroom gasped when they learned that a verdict had been reached. And now in the months going forward, this could have major implications on the country as a whole.
It was an extraordinary and unprecedented moment in American legal history. Donald Trump, former president of the United States, guilty. Trump sat expressionless as the verdict was read, but afterwards he was infuriated.
This was a disgrace. This was a rigged trial by a conflicted judge who was corrupt.
That is why Trump's 34 felony convictions in New York remain so consequential. A Manhattan jury heard the evidence, reviewed records, listened to testimony, examined payments, and returned a unanimous guilty verdict on count after count. 34 felony convictions. That had never happened to an American president before, and now that the Supreme Court has refused to stretch immunity over private conduct, Trump's effort to use the presidency as a blanket escape from sentencing becomes much harder. This next part shows why Judge Juan Merchan now faces a historic sentence.
Not Mitch, and the former president is already lashing out at this judge, saying that Judge Juan Merchan hates him and was handpicked by the DA, by Alvin Bragg, for that very reason. A lawyer for Mr. Trump saying Sunday that he doesn't believe the judge is biased, but adding that his team will let this process play out and pursue legal options if needed, because Mr. Trump's team vehemently believes that this is all political persecution, or, in Mr. Trump's words, a witch hunt.
Sentencing decision. Judge Juan Merchan now has to deal with one of the most complicated sentencing questions in American history. Each felony count carries potential prison exposure, though almost no serious observer expects the maximum theoretical sentence. The judge must weigh the seriousness of the conduct, the impact on election integrity, Trump's lack of remorse, and the need to deter similar conduct in the future. At the same time, Trump's status as a first-time nonviolent offender may work in his favor. But the case is unlike anything the courts have handled before because the defendant is not just a private citizen. He is a former president, and in this script's framing, someone holding the center of national political power. Now watch why a prison sentence could create questions America has never faced.
At constitutional crisis, this, I think, is the real constitutional crisis. We've had another Obama-appointed judge, this time Indira Talwani, blocking the Trump administration from cancelling a program introduced by Joe Biden that granted parole and the right to work to more than 500,000 immigrants from countries like Haiti and Venezuela.
Before. That creates questions no one has ever fully answered. What happens if a sitting president is sentenced to prison? How does the Secret Service protect him? Can a president carry out duties from a correctional facility? Would imprisonment trigger the 25th Amendment? Would Congress have to respond? The Constitution does not automatically remove a president because of a criminal sentence. Removal happens through impeachment and conviction, resignation, or the 25th Amendment process. That means a prison sentence could create a constitutional crisis.
Investigators say Trump obstructed the investigation by deleting security camera video. 2 Trump associates are also facing charges, one telling another employee that the boss wanted the server deleted. WCNC Charlotte's Bree Jackson is in Washington with the latest.
Former President Donald Trump is being charged with an additional count of willful retention of national defense information and 2 new obstruction counts.
Unlike anything in American history. Here is why the classified documents case still remains exposed under this ruling. The ruling also affects Trump's other legal battles. In the classified documents case, prosecutors allege that Trump kept sensitive government records after leaving office and resisted efforts to return them. That conduct happened after the presidency, which makes it very difficult to describe as an official presidential act. If documents were moved, hidden, or withheld after Trump left office, that is post-presidential private conduct. The Supreme Court's framework does not give him much protection there. Now let's see why the Georgia election case remains another major danger point. The Georgia election case is another major danger point. That case focuses on efforts to overturn the 2020 election results in Georgia, including pressure on state officials, the call asking officials to find enough votes, and the alleged false elector scheme. Trump may argue that some conversations touched official duties, but much of the conduct appears connected to his role as a candidate trying to stay in power, not as a president carrying out constitutional responsibilities. Campaigning and attempting to change election outcomes are not automatically protected official acts. So the ruling is complicated. It may help Trump in certain areas, especially where prosecutors try to use evidence connected to core presidential functions. For example, some communications with the Justice Department may be shielded. But the ruling does not erase the cases against him. It does not protect private conduct. It does not give immunity for personal schemes. It does not transform campaign activity into official presidential duty. That is why, despite parts of the ruling helping presidents generally, Trump still faces serious legal exposure. The political impact is just as intense. Trump appointed 3 of the justices who shaped the current Supreme Court. He treated those appointments as one of the greatest achievements of his presidency. He told supporters that the court would protect conservative power for a generation, but when he needed the court to create an immunity shield broad enough to rescue him completely, the court did not give him that total victory. That undercuts the idea that every legal setback comes only from Democratic judges or partisan prosecutors. Some of the judges and justices ruling against his broadest claims are part of the judiciary he helped build. That creates a serious problem for the Republican Party. Defending a president or former president with felony convictions and possible sentencing is politically dangerous, especially with moderate voters, suburban voters, and independents. Trump's base may still see every prosecution as a political attack, but many other voters may see a different picture. A jury found him guilty, courts rejected his broad immunity claims, and even conservative justices refused to make him untouchable. The persecution argument becomes weaker when multiple parts of the legal system, including Trump-shaped institutions, refuse to accept his most extreme claims. The possibility of a constitutional crisis now hangs over everything. If Trump receives a sentence involving incarceration, even if appeals delay the outcome, the country enters unknown territory. Can a president govern while sentenced? Can the appeals process continue while he remains in office? Would Congress be forced to act? Would the cabinet consider the 25th Amendment? These are no longer abstract questions for law professors. They could become real political and constitutional questions in the near future. The larger meaning of the ruling goes beyond Trump personally. The Supreme Court has reinforced that the president is powerful, but not untouchable. The office receives protection where protection is necessary for constitutional function, but the person holding the office remains a citizen under the law. Private crimes remain private crimes. Personal wrongdoing does not become immune simply because the person later becomes president or returns to political power. That principle matters for every future president. Anyone who runs for the office now knows the White House does not erase private misconduct. It does not create lifetime immunity. It does not protect unofficial conduct. It does not turn campaign schemes into constitutional duties. The ruling preserves presidential power for official functions, but it also warns that the law still reaches beyond the Oval Office. The international message is also important. America's adversaries may point to this chaos and claim democracy is unstable. But the stronger message is that American institutions can still hold powerful people accountable. In authoritarian systems, leaders do not face independent courts, juries, or judges who rule against them. In the American system, even a president who appointed Supreme Court justices can still lose before that same court. That is not weakness. That is institutional resilience. The coming months will test that resilience. Sentencing in New York will be historic. Appeals will follow. Other cases will continue. Prosecutors will push forward. Trump's lawyers will challenge every ruling. His allies will call the process political persecution, while his opponents will call it accountability. The country will be watching a legal process unfold at a level it has never seen before. But the central lesson is already clear. The presidency is not a get-out-of-jail-free card. The White House does not create a permanent exemption from criminal law. Official acts may receive protection, but private conduct does not disappear behind the presidential seal. Trump must still face the cases that fall outside protected presidential power. And for the first time, the possibility of real punishment feels closer, more serious, and harder for him to escape.